Good morning and welcome to the South Carolina Public Service Commission. Today is Tuesday, December 3rd at approximately 10 a.m. We are here for case number 2024-179-G, which is the P&G Depreciation Study. First, a roll call of commissioners. It appears that all commissioners are present in the hearing room. I will now ask Ms. Wessinger-Hill to read the docket.
Thank you, Mr. Chairman, and good morning, commissioners and all those who are joining us in the hearing room or virtually. This is the proceeding in docket number 2024-179G. The docket concerns the review of the depreciation study of Piedmont Natural Gas Company Incorporated as required by Commission Order number 2022-574. The hearing was scheduled and noticed by the clerk and published in local newspapers to begin today, December 3rd, 2024 at 10 a.m. Mr. Chairman and other members of the commission, the docket is in order.
Thank you very much. Would the parties now please introduce themselves, beginning with Piedmont?
Good morning, Chair Powers, members of the commission. My name is Jason Richardson. I'm outside counsel for Piedmont Natural Gas Company. I'm here with Brian Franklin, who has an outstanding motion for admission via Pro Hoc Vice. Again, we appreciate the opportunity to be before you this commission before this morning and look forward to this proceeding.
All right. And we're going to grant the motion for Pro Hoc Vice admission of Attorney Brian Franklin. I don't think that's in the record yet, but it is now.
Thank you, Chair Powers. Appreciate it.
And welcome. ORS.
Yes, good morning, Chair Powers, members of the commission. Hope you all had a good Thanksgiving. Joshua Austin on behalf of the Office of Regulatory Staff. And with me this morning, I have Mr. Chris Huber.
Welcome, gentlemen. Is there anything we need to discuss before beginning the case?
Yes, sir. I have one preliminary matter and a couple of comments, if that's all right.
Proceed if you would.
Good morning, Chair Powers, Vice Chair Williams. You can sort of see him over there. And members of the commission. As the commission's aware, Piedmont Natural Gas Company and ORS executed a settlement agreement, which was filed on November 26th and resolved all outstanding issues between the parties. Though the parties agreed on most aspects of the depreciation study and depreciation rates, there were several accounts where the parties had disagreement on the appropriate rates, as discussed in testimony. As set forth in the agreement, the parties have agreed to resolve those different opinions with the proposed annual depreciation rates agreed to by the parties as included in Settlement Exhibit A. I'd like to thank the parties for working collaboratively to reach a settlement that is reasonable in the public interest and in accordance with law and regulatory policy. And at this time, I would request that the settlement agreement and Settlement Exhibit A be marked for identification and entered into the record as the first hearing exhibit. Thank you.
All right. The settlement agreement marked as Exhibit A will be identified and will be placed in the record as our Exhibit number 1.
Thank you. And just for clarity of the record, that is both the settlement agreement and settlement agreement Exhibit A as a composite exhibit?
All right. It will be as a composite exhibit.
Thank you. That's all I've got, Chair Powers. Thank you.
All right. Any other matters we need to discuss first?
No, Chair Powers, just echoing Mr. Austin's comments and that we appreciate the opportunity to work with ORS and reach a settlement in this matter.
All right. Well, we certainly appreciate the parties working together and working this out. I guess just from my prior experience, I would like to ask a couple of questions and then in turn, each party's attorney respond. Do you feel, I'll start with Piedmont, do you feel your client had ample opportunity to participate meaningfully in this case, including engaging in the discovery process, pre-filing testimony, receiving and reviewing all relevant evidence, complete disclosure of all relevant evidence?
Yes, Chair.
Okay, and you feel that your client entered into this settlement negotiation in good faith?
Yes, Chair.
All right. And you feel your clients had ample opportunity to review the terms of the agreement?
Yes, sir.
And you're satisfied with it?
Yes, Chair.
All right. I would ask the Office of Regulatory Staff the same questions. Do you feel the agency had ample opportunity to participate meaningfully in this case in discovery, pre-filing testimony, receiving, reviewing all relevant evidence, and complete disclosure of all relevant information.
Yes, sir.
Did your client participate in the settlement negotiation in good faith?
Yes, sir.
And you've had ample opportunity to review the agreement and wish the court to approve it?
Yes, sir.
All right, thank you very much. All right, Piedmont, you may proceed.
Yes, Piedmont calls to the virtual stand, Mr. Dane A. Watson.
Good morning, Mr. Watson. Can you hear me okay?
Yes, I can, sir.
Would you please raise your right hand? Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. You may proceed.
Mr. Watson, can you please state your name for the record?
My name is Dane Watson.
And by whom are you employed and in what capacity?
I am managing partner of Alliance Consulting Group.
And did you prepare or cause to be prepared under your direction 23 pages of direct testimony pre-filed on August 7th, 2024?
Yes, I did.
And if I asked you all the questions contained in your pre-filed direct testimony here today, would your answers be the same?
They would.
Chair Powers, I move that the pre-filed direct testimony of Mr. Dane Watson be entered into the record as given orally from the stand.
The pre-filed direct testimony of Mr. Dane Watson will be entered into the record as if given orally from the stand.
And Mr. Watson, did your pre-filed direct testimony include two exhibits labeled DAW1 and DAW-2?
Yes, they did.
And Chair Powers, I move that the exhibits labeled DAW-1 and DAW-2 be entered into the record as the next composite hearing exhibit.
The pre-filed exhibits of witness Watson identified as DAW-1 and 2 are marked for identification and will be placed in the record as exhibit number 2.
Thank you. And Mr. Watson, did you prepare or cause to be prepared under your direction 23 pages of rebuttal testimony pre-filed on November 7th, 2024?
Yes, I did.
And if I asked you all the questions contained in your pre-filed rebuttal testimony here today, would your answers be the same?
Yes, they would.
Chair Powers, I move that the pre-filed rebuttal testimony of Mr. Dane Watson be entered into the record as given orally from the stand.
The pre-filed rebuttal testimony of Mr. Dane Watson will be entered into the record as if given orally from the stand.
Thank you. And Mr. Watson, your pre-filed rebuttal testimony includes 6 exhibits labeled rebuttal exhibits DAW-1 through DAW-6.
Yes.
Chair Powers, I move that the rebuttal exhibits DAW-1 through DAW-6 be entered into the record as the next composite hearing exhibit.
The pre-filed rebuttal exhibits of witness Watson identified as rebuttal DAW-1 through 6 are marked for identification and we place the record as exhibit number 3.
Thank you. And Chair Powers, the parties have stipulated that witness Watson is considered an expert in the field of depreciation.
Thank you very much.
And Chair Powers, if it pleases the commission, in lieu of testimony, summaries, or settlement testimony, the company requests to ask Mr. Watson a few brief questions related to the party settlement.
All right.
Mr. Watson, are you aware that on November 25th, 2024, the parties to this proceeding filed a settlement agreement resolving all matters?
Yes, I am.
And are you familiar with the substantive terms of the settlement agreement?
Yes, I am.
And do you believe the settlement agreement is a fair resolution to this case?
Yes. From my understanding, the settlement agreement is the result of earnest, good faith negotiations between the company and ORS that, in the spirit of collaboration, represents compromises from each party's original position. I find it to be a balanced resolution of all issues in this proceeding.
And do you have any final comments regarding the settlement agreement?
Yes. I am aware that the company fully supports the settlement agreement and respectfully requests the commission consider approval of the settlement agreement in its entirety and without modification. I too recommend that the commission approve the settlement agreement in its entirety without modification as a reasonable and appropriate resolution of the matters in this docket that's consistent with the public interest.
Thank you. Chair Powers, the parties have waived cross-examination of each other's witnesses. As a result, Mr. Watson is available for questions from the commission.
Thank you very much. Commissioner questions?
Mr. Chairman.
Commissioner Belser.
Thank you. Good morning, Mr. Watson. Thank you for appearing today.
Yes, good morning.
Can you hear me okay?
Yes, I can.
There were I think there were 5 accounts where there was disagreement on the rate between your study and ORS's study. Is that correct?
That is correct, yes.
Okay. Are there different methodologies that can be used for calculating depreciation rates?
Yes. The depreciation rate calculations, there is the ORS witness and I use the same methodology to calculate the rates. The differences were related to the lives and the analytics and other information used to determine the lives that underlie those rates.
And I think you you took exception to ORS's study and indicated that there needed to be some more consideration given to operational performance. Would that be a correct statement?
Yes, it would.
Okay. And why would the operational performance need to be included in a study, in your opinion?
Okay. The analytics that we use looks at long-term history. So in other words, both Mr. Garrett and I used something called actuarial analysis to look at effectively the life cycles historically of the assets that the company uses to serve customers. But what it doesn't do well is look at, at the end of the day, what we're trying to do is determine how long the assets that are currently being used will last. And current considerations such as changes in operations or programs or things that would suggest that the long-term history is not necessarily as representative of the future is something that you can only see well by looking at the operations and other factors other than just the long-term life cycles from history. So projecting into the future needs to understand the operations and how the operations are being performed within a company.
Okay. Is there much subjectivity from one expert's method to another's? How does subjectivity of play into what an expert might recommend?
There is some level of subjectivity. The history, again, when you look at the analytical tool that we use, you can see trends through time in some cases. So how much you give weight to the trends, how much weight you give to operational changes can also come into play in determining what the best projection in an expert's opinion of the life of the assets going forward would be.
Okay. Based on your study, which and things that have happened since you've pre-filed your testimony, do you have an opinion based on your experience and your study and methodology whether the settled upon rates are within a zone of reasonableness of your results?
Yes, I do. I believe, although I think my rates or the lives that I set are the most appropriate, I believe that the settled lives are within the realm of reasonableness from the operations of the company.
And based on your experience and your work, your study methodology in this case, do you have an opinion on whether the rates in the settlement agreement are reasonable for Piedmont's plan?
Yes, I do believe that they're reasonable.
Okay. Thank you very much. Mr. Chairman, that's all I have.
Thank you, Commissioner Belser. Any further commission questions?
Chair
Commissioner
Powell.
Thomas.
Thank you, sir. Good morning, Mr. Watson.
Good morning.
Had a couple of questions for you. So, in your report on page 3, talk about this is due to the settlement life changes for South Carolina in 2022 for certain transmission and distribution. It is no longer easy to quantify between the Carolinas and corporate and Tennessee. And please refer to Appendix C for further details. Can you talk a little bit about, just expand on that for me, please?
I'm fine. I'm trying to find my page. If you'll give me just a second. And it's in the report on page 3. I'm sorry, sir, just to catch up to you.
Let's see. It's page 3 at the bottom, but at the top it's page 7. Then on the side it's page 9. So a lot of
Okay, is it the testimony, not the report? Is that correct, sir?
yeah, it's at the beginning.
Okay, I was looking in the report.
It's the executive summary, I believe. No, it's actually the report. So you got the table of contents, and then the purpose, and the study results, and it's the last thing in the study, last couple of sentences in the study results.
Okay.
Are you getting there?
I am. And so at the top of the page, it's page 3, it says.
At the top of the page, it's page 7.
Okay, thank you, sir.
Sorry about that.
Is that all, Commissioner? Oh,
I apologize. It's not, I'm looking at it on the screen and it's,
Well, I understand that. It's kind of strange how the page numbering works when we move into these things. But it's the last part of the study results. So you have the table of contents. So if you see the table of contents,
yes,
and then the next page gets into the purpose,
yes, sir.
and then the next page gets into the study results. And so what I was referring to is the last part of the study results. That's where I was reading from. It's the last 2 sentences, actually, due to the settlement life changes for South Carolina in 2022. Are you seeing that?
I'm sorry, sir. I'm still struggling. So the beginning of my testimony, I found the position and qualifications, and then previously submitted testimony, then the purpose of direct testimony. Am I,
Mr. Chairman, can I help the witness a little bit?
please, if you would?
Are you looking at your Exhibit 2, or are you looking at the application, Mr. Watson?
Well, I was looking at the filed direct testimony.
Okay, it's page 7 of 129. I believe that is your Exhibit 2.
Okay, so it's the-
DAW 2, page 7 of 129 in the upper right corner.
okay. Thank you. I was looking at the testimony. I apologize, not the report itself. So I was referring to Appendix C is the list of the different lives that were recommended for the different states. And if you went to that appendix, you would see that um, there's not uniform lives across all of the different jurisdictions. And so, um, because of the different settlements or the settlement, the lives are different from North Carolina corporate and existing South Carolina and Tennessee. So we're proposing a system-wide um, common life for each of the accounts. And so the intent of that sentence was just to say a direct comparison, um, because the lives are different between the different states, and then looking at a system-wide life recommendation. A direct comparison is not um, applicable. You have to look at, here's the system-wide life that we're recommending across the different states, and here's the individual lives that were accepted by different jurisdictions. That was the intent of that particular sentence.
All right. And just to carry that a little bit further, in terms of the 2-state and 3-state assets, let's just start with the 2-state. What are some of the assets that are allocated across the 2 states, North and South Carolina?
I believe it's basically general type of assets that are used between those states. You know, it would be um, generally what we'd call general plant, computer systems, equipment, things that would be used across multiple jurisdictions. As
Okay. And so I'm looking at the exhibit that's attached to the settlement agreement, Settlement Exhibit A. And it gets into page 2, Piedmont 2-state common plant. And it talks about the storage plant and the distribution plant and general plant. And I guess basically I'm trying to understand, you know, what's being allocated between 2 states. My understanding is that, for example, distribution plant, I mean, just thinking about meters, it seems to me like meters are located where they are. They're either in North Carolina or South Carolina. That's just one example. And if you want to get into the storage plant, account 263.3, compressor equipment. I mean, there are no lines that go across the North Carolina, South Carolina state line, I don't believe. Is that your understanding?
I believe that the assets that are managed on a multi-state, I guess, operations are in the 2-state or the 3-state. And I'm not clear as to how the company would assign those between the 2-state and 3-state. I know that I believe that the footprint of the gas and the pipe and other assets would be within the state would be in the single state jurisdictions. In the 3-state, for example, property assets, meters, there's about $24 million worth of meters that are allocated amongst the 3 states. The origin of that allocation or the reason for it separating, I think that's a more of a company question. We analyze those separately. You know, the 2-state assets and the 3-state assets for their lives. But the origin of why they operationally would be in a two-state or a three-state, I think that's more of a company-specific question, sir.
All right, well, let me ask another question, and again, this relates to the settlement Exhibit A, and you have account by account rates, depreciation rates, and
Yes, sir.
just starting out with the first section, the transmission plant, total transmission plant, then you have a rate for the total transmission plant, and just want to make sure that I understand when you're actually calculating depreciation, that's calculated on an account by account basis. So,
Yes, sir.
yeah, so the total transmission plant is just what, like a weighted average rate? It doesn't really figure into a depreciation calculation. Would that be correct?
That would be correct, sir. The depreciation rates in the settlement are designed to be applied on an account by account specific basis. So the dollars of assets within a specific account, such as 267, which is transmission mains, the 1.79, I believe it is, would be applied against the gross investment for that particular account.
All right, that's all I have for now. Appreciate that. Thank you.
Thank you, Commissioner Thomas. Any further commissioner questions? Commissioner Caston.
Thank you. And good morning, Mr. Watson.
Good morning.
I believe earlier you stated that you had reviewed and supported the settlement agreement, correct?
Yes, sir.
And relative to this agreement, how does, in your opinion, how does the agreement provide benefit to the company's customers?
I think it is depreciation by its very nature is designed to recover the cost of capitalized assets over the life of the assets. While I stand behind, that I think the lives that I proposed are more representative, I believe that, there is room to move within the area in the realm of reasonableness. And so I believe that the settlement basically takes into account the differing opinions of ORS and the company and comes to a compromise that is fair to customers. It allows for the recovery of the cost of assets, providing a level of intergenerational equity between various groups of customers over time.
All righty. Thank you, Mr. Watson, and no more questions.
Thank you, Commissioner Caston. Commissioner Williams.
Thank you, Chair Powers. Mr. Watson, welcome. I just have a quick follow-up. Intergenerational equity. I think I know what you mean, but I'd like to hear you tell me what it means.
Well, what I mean by that is that different customers through time, the goal of depreciation is to, on a straight line basis, ratably, in other words, recover the cost from customers. When you set the life at a reasonable level, that you could reasonably expect to be the life of the assets, customers in different generations or different periods of time would pay the same amount for the same level of service for the assets. So in other words, different customers at different times period pay their same share of the assets based on the usage.
Thank you very much. I appreciate it.
Thank you,
Chair
Commissioner
Powers.
Williams. Commissioner Thomas.
Thank you. So just had a follow-up question in general on depreciation studies. So Piedmont does depreciation studies every 5 years, and I just wondered, is that common for the utility industry?
Yes, it is. The general recommendation is somewhere between 3 and 5 years. In part, some are done earlier if there are material changes in the way the operations are performed. But as a general rule of thumb, I think the depreciation industry would suggest a 3 to 5 year range is reasonable.
Okay, and does that apply to electric as well as gas?
Yes, I would assume so. I mean, it depends. If your utility is very static, then it could be longer. But the general rule would be conditions should be relooked at every 3 to 5 years, in my opinion.
All right, thank you. That's all I had.
Thank you, Commissioner Thomas. Anything further from the commission? Hearing none, thank you. Your witness may stand down.
Thank you, Chair Powers. And that concludes the company's case.
Thank you very much. Officer Regulatory Staff.
Yes, sir. First, the ORS would call Mr. David Garrett to the stand.
Mr. Garrett, good morning.
Good morning.
Can you hear me okay?
Yes,
Would you please raise your right hand? Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Your witness.
Thank you. Mr. Garrett, good morning. Could you please state your name for the record, or your full name for the record?
My name is David Garrett.
By whom are you employed and in what capacity?
I am the managing member of Resolve Utility Consulting, and I'm a consultant for the ORS in this case.
Are you the same David J. Garrett who prepared or caused to be prepared 26 pages of pre-filed direct testimony in this docket on October 10th, 2024?
Yes.
Do you have any corrections or edits to your pre-filed direct testimony?
No.
If I ask you the same questions as those posed in your direct testimony today, would your answers be the same?
Yes, they would.
Chair Powers, I would move that Mr. Garrett's 26 pages of pre-filed direct testimony be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Garrett will be entered into the record as if given orally from the stand.
Thank you. And I'm going to try and not mess this next one up. Mr. Garrett, did you also prepare or cause to be prepared an appendix, including appendices A, B, and C, as well as 12 exhibits to your direct testimony entitled Exhibit DJG-1 through Exhibit DJG-12?
Yes.
Do you have any changes or corrections to your appendices or your exhibits?
No.
Chair Powers, ORS would ask that Mr. Garrett's appendices A, B, and C, along with his 12 exhibits DJG-1 through DJG-12, filed with his direct testimony, be marked and entered as the next composite hearing exhibit.
The pre-filed appendix A, B, and C, as well as the pre-filed exhibits of witness marked DJG-1 through DJG-12 will be entered into the record, marked for identification, placed in the record as exhibit number 4.
Thank you. Mr. Garrett, did you also prepare or cause to be prepared 7 pages of pre-filed sir rebuttal testimony filed in this docket on November 22nd, 2024?
Yes.
Do you have any changes or corrections to your pre-filed sir rebuttal testimony?
No.
If I ask you the same questions today as posed in your sir rebuttal testimony, would your answers be the same?
Yes, they would.
Chair Powers, ORS would ask that Mr. Garrett's 7 pages of pre-filed sir rebuttal testimony be entered into the record as if given orally from the stand.
The pre-filed sir rebuttal testimony of Mr. Garrett will be entered into the record as if given orally from the stand.
Thank you. Mr. Garrett, are you aware that the parties entered into a settlement agreement that was filed in this docket on November 25th, 2024?
Yes.
Have you reviewed the settlement agreement and Exhibit A attached thereto?
Yes, I have.
Do you support the settlement agreement as being in the public interest and request the commission approve the settlement agreement in its entirety?
Yes.
Thank you. Finally, the parties have stipulated that Mr. Garrett is an expert in depreciation, and I would request that he be qualified as such.
No objection to that, then he is so qualified.
None here. Thank you.
Thank you. And the parties have waived cross-examination, so Mr. Garrett is available for questions from the commission. Thank you.
Thank you, sir. Commissioner questions? Commissioner Belser.
Thank you, Mr. Chairman. Good morning, Mr. Garrett.
Good morning.
You may have heard some of the questions that I asked Mr. Watson. Do you agree that there are different methodologies for, or let me just say, are there different methodologies for estimating depreciation rates and that can be used that are both that may be reasonable?
Yes, I would agree with that, and I would also agree with Mr. Watson's explanation when he says that, you know, both he and I essentially did use the same methodology in this case, which I would describe as probably the most common methodology to use. There's others that are also considered reasonable, but just not as common. So we did use the same methodology. We just had some different opinions on these few accounts with regard to the service lives in particular.
So is there a level of subjectivity that an expert can apply when conducting a study or methodology?
Yes, I would agree with that, and that kind of goes in the realm of the judgment, professional judgment part of the process will have some subjectivity to it.
Well, I think your term on professional judgment is probably better than subjectivity, so I thank you for that. Recognizing that your study recommended different rates from some of the categories of plants, do you have an opinion based on your experience and your study and methodology whether the settled upon rates are within a zone of reasonableness of your results?
Yes, I would say that the settled rates are within a zone of reasonableness. I think for really estimating the service life for any account in any case would necessarily have a zone of reasonableness rather than an exact right or wrong answer. And essentially the rates that the parties agreed on, the settled rates, are in between my file position and Mr. Watson's file position. So I would say they are within that zone of reasonableness.
And based on your experience and your study and methodology results, do you have an opinion on whether the rates contained in the settlement agreement are reasonable for Piedmont?
Yes, I believe they are reasonable for Piedmont and for customers.
And you've been qualified as an expert, so that's your expert opinion, right?
Yes, that's correct.
Thank you very much. I appreciate your patience with me and for answering my questions. That's all I have,
Thank
Mr.
you.
Chairman.
Thank you, Commissioner Belser. Any further commissioner questions? Hearing none. Anything further from this witness?
No, sir, we would ask that he could stand down, please.
He can stand down. Thank you very much. Mr. Garrett.
Thank you.
Okay. That's fine. We're going to take about a 10-minute break, and then we'll let you put your other witness up while we get the equipment straight.
Yes, sir. Thank you.
We're in recess. We are back in the hearing at 2024-179-G. Testimonies being taken from the witness for Office of Regulatory Staff, and you can call your next witness. Also, let me, for the record, all commissioners are present here in the hearing room.
Thank you, Chair Powers. ORS calls Michael Seaman Wynn as its next witness.
If you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Mr. Seaman Wynn, will you please state your name for the record?
Michael Seaman Wynn.
By whom are you employed and in what capacity?
I'm employed as a Deputy Director of Energy Operations at the Office of Regulatory Staff.
Are you the same Michael Seaman Wynn who prepared or caused to prepare 5 pages of pre-filed direct testimony that were filed in this docket on October 10th, 2024?
Yes, I am.
Do you have any corrections or edits to your pre-filed testimony?
No, I do not.
If I were to ask you the same questions today as those posed in your direct testimony, would your answers be the same?
Yes, they would.
Chair Powers, ORS asks that Mr. Seaman Wynn's 5 pages of pre-filed direct testimony be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Seaman Wynn will be entered into the record as if given orally from the stand.
Mr. Seaman Wynn, are you aware the parties entered into a settlement agreement that was filed in this docket on November 25th, 2024?
Yes.
Have you reviewed the settlement agreement and the Exhibit A attached to it?
Yes, I have.
Do you support the settlement agreement as being in the public interest and request the Commission approve the settlement agreement in its entirety?
Yes.
Chair Powers, the parties pursuant to the settlement agreement have waived cross-examination, so Mr. Seaman Wynn is available for questions from the Commission. Thank you.
Thank you very much. Any Commissioner questions? Commissioner Belser.
Thank you. Good morning, Mr. Seaman Wynn.
Good morning.
Did ORS calculate the impact that would result from the rates contained, or the depreciation rates contained in the settlement agreement?
Given the dollar amounts that were associated in the application, yes, I believe that was part of the analysis and the work papers behind the settlement agreement.
Well, we've got is it in the Exhibit A?
No, ma'am, it is not.
Okay.
The rates themselves, the different percentages and depreciation rates are within the settlement Exhibit A.
But you don't know the impact?
Off the top of my head, I believe it was the company requested if I'm remembering correctly, a $42 million change in depreciation rates, and I believe that the settlement shaves about $1 million off of that. However, of course, that'll be subject to change once the actual rates are, whether the rates are approved by the Commission at the time of the company's next RSA or rate case filing. So,
and that's my next question. These rates would be used in the next RSA that would come next year?
that would be, yes, ma'am, that is one of the terms of the settlement agreement.
And as the entity charged with looking after the public interest as defined by statute, can you explain how the proposed settlement agreement and the depreciation rates contained in the settlement agreement serve the public interest?
Well, I would agree with the technical explanations that Mr. Watson gave earlier when you posed that question to him. I believe that the rates provide the company with adequate means to continue to provide excellent, high-quality, reliable service, and that the depreciation rates are just and reasonable.
Thank you, Mr. Seaman-Wynn. Nothing further, Mr. Chairman.
Thank you, Commissioner Belser. Any further commissioner questions? All right. That's, anything else from ORS?
Nothing further. Thank you, Chair Powers. And that concludes ORS's presentation of its case.
I'm sorry, I could not hear you.
Oh, wasn't close enough. I'm sorry. Nothing further, Chair Powers, and that concludes ORS's presentation.
Thank you very much. You're free to go. Is anything further from either party?
Nothing, Chair Powers.
No, sir.
Well, gentlemen, thank you for your hard work on this case and getting it worked out. And we certainly will consider the agreement that's been presented and put into evidence. Your Christmas present is going to be proposed orders are not due until January 7th. So you don't have to work on them Christmas Eve.
Thank you, Chair Powers. As much I was looking forward to working on Christmas Eve, but I sincerely appreciate it.
I thank you, and my wife thanks you.
All right. If there's nothing further, then we are adjourned.